Hello everyone, I'm Yash and with me I have Siddharth. We're both chartered accountants and this is a special report of our podcast, The News Cocktail. Here we want to talk about the recently settled case of the Vodafone International Holdings versus Union of India.
You must be aware of Sunny Deol's famous dialogue, Tariq pe Tariq, Tariq pe Tariq. This this applies very accurately to this case because this dispute between Vodafone and the Indian tax department has been ongoing for around 13 or 14 years since 2007, and it has been a very long drawn battle which still might not be over. I mean, even after the arbitration award that is granted, we don't know, it might not be over. But before we dive deeper into the finer details, I think it's very important to understand some sections and some terms of the Income Tax Act.
So let's take a look at some key terms and sections as Siddharth mentioned. So one of the most important sections to remember while going through this whole case will be this section 9 subsection 1 and clause 1, which essentially, long story short, which essentially says that all incomes which are arising from transfer of any capital asset situated in India will be deemed to accrue or arise in India, no matter whether that income is accruing to a non-resident or a resident or a foreign person. It doesn't matter. The asset has to be situated in India.
Yeah, I mean, this is a very important definition, because if a capital asset is transferred which is located outside India, then what this means is that the income from such transfer will not arise in India, which means that the tax authorities, they cannot tax it. They don't have the jurisdiction and they cannot charge income tax on such income and on such transfer in India.
Yeah. And then there is general anti-avoidance rules, basically GAR, which we call it in usual terms, under which if the IT department deems that any deal is structured mainly for the reason of tax avoidance or, circumventing tax laws, the IT department can make that transaction taxable. And it says that timing of the deal is irrelevant. So there you have your GAR. Now, coming towards TDS or tax deducted at source, it is nothing but an estimated amount which from while paying some of the payments, it has to be deducted while the payment is made to certain persons as per Income Tax Act. Now, Section 195 says that any person making a payment of any sum chargeable to tax in India and that payment is made to any non-resident or foreign company, then the TDS has to be deducted mandatorily, as in whatever amount is supposed to be paid to such foreign person or foreign company, a certain calculated amount has to be deducted and deposited to the income tax authority.
And remember, only those sums which are chargeable to tax, only on those payments TDS has to be deducted. So if you're making any transfer or if you're having any transaction which is not covered under income tax laws, then you don't have to deduct TDS on that.
Yeah, and lastly, two more sections. So first of all, there is section 201, subsection 1, which says that if any person who is liable to deduct TDS does not deduct the TDS and does not pay the TDS to the IT department, he shall be deemed to what we call an assessee in default, and he shall have to pay the tax from his own pockets. That will become essentially a cost. And also we have section 201, which essentially says that it levies a combined 2.5% interest per month of default, for every month for which you did not deduct and pay the TDS to the government. It will charge a 2.5% interest. Then there is 271C, section 271C, which says that a penalty of equal amount, an amount equal to TDS, will be collected along with the TDS, the amount in default.
And these are very important sections, and by chance if you were not paying attention, I would say listen to it once again, because before we break down the case, I think it's very important to understand these sections, and it will make very easy for you guys to understand what we are going to cover later on. So apart from the sections, now also let's evaluate the parties that were involved in this case. So the most important party is Vodafone International Holdings, which is a subsidiary of Vodafone PLC. And Vodafone International Holdings is a company against which the case is ongoing. We know that. And then we have Hutchison Telecom International Limited, which is a listed entity in Hong Kong. We also have CGP Investments, which is a subsidiary of Hutchison Telecom International, and it's based in Cayman Islands. And finally, we have Hutchison SR, which is based in India and which is a joint venture between CGP Investments, which owns around 67% of Hutchison SR, and India's SR Group, which owns 33% of Hutchison SR. So Hutchison SR Limited, which we'll later call it as HEL, is a joint venture between CGP Investments and the SR Group, India's SR Group. And I know this is a bit technical, this is a bit heavy even for the people who are listening to it, but the terms and the parties involved, understanding them is very important before we break down the case bit by bit. Let us begin with the facts of the case now with a little bit of role playing.
Yeah. So again, I would like to compliment what Siddharth said. We know that this all sounds a bit technical, but we'll also give a YouTube video along with this, where there'll be some sort of visual explanations also. Yeah, that will help you understand the case. Now, moving forward, I will act as Vodafone International Holdings, who is the SSA in this case, and Siddharth here will be the Income Tax Department. So this all began in February 2007 when Vodafone International Holdings, which means me, bought 100% stake of CGP Investments. And the company from whom I bought this investment is Hutchison Telecom, the Hong Kong based entity basically. And what this did effectively was, when I bought the CGP Investments shareholding, I got the control of Hutchison SR Limited also, because CGP held a 67% shareholding in Hutchison SR Limited of India. Now, here's the thing. Both the entities, which is a Vodafone International Holdings and Hutchison Telecom, are based out of India. The asset which was transferred, basically the shares of CGP Investment, those are also not based in India. And hence, this entire transaction is outside of Indian law's jurisdiction. If that's not enough, tax is supposed to be paid by the person who sells the asset, or to whom the income accrues, who owns the income, which in this case was Hutchison Telecom Group of Hong Kong. But you might be wondering why the income tax department comes to me, which is the buyer. I am the buyer. As you, I am also wondering the same thing. So let's hear what the department has to say for itself.
So no, I'll clarify what the income tax department has to say, which is me basically. The reason why Vodafone International Holdings bought a stake in CGP Investments was to get indirect ownership into the Indian company. What this means is, like, directly or indirectly, it is a sale of Indian assets, and therefore the income tax department, had to come into the picture. I mean, and Vodafone International Holdings should have deducted TDS under section 195, because, like I mentioned, this is an indirect sale of assets of Hutchison SR Limited, which is an Indian company, and therefore the tax department has the jurisdiction to tax such sale. And therefore, when Vodafone International Holdings makes its payment, the sale consideration that it paid to Hutchison Telecom, which is based in Hong Kong, they should have deducted TDS, but they did not. And that is why I sprung into action and I had to file a notice in this behalf.
Now, I reverted saying that Hutchison Telecom International Limited was not liable to pay tax on the whole transaction, because as per law, Indian IT department has jurisdiction only when there is a transfer of Indian asset. And that's when section 9, subsection 1 will come into play. Now, here the transfer of the shares of CGP Investment is, a foreign asset. It's not located in India, and neither of the parties are Indian residents. So the Indian Income Tax Act is not applicable, and it cannot give power to the Income Tax Department for charging the tax. Now, I go to Bombay High Court with my case, and also such an interpretation by the tax authorities of the tax laws was very unheard of. So I went to the Bombay High Court and presented my case.
And what I say, the income tax department says, is that the effect and the purpose of the transaction was to obtain control of Indian assets, because you're not going to buy some company located in Cayman Islands. The purpose why you bought this stake in CGP Investments was to, ultimately get your holding in the Indian company, because that is where you're going to be doing your business. So, tax should have been levied over it. And Bombay High Court actually agreed with me, and I issued an order claiming jurisdiction over such transaction. But all of this took a lot of time. It took around 3 years. And finally, I issued the notice of demand on May 2010. Vodafone moved to Bombay High Court. They contested the notice that I gave, but Bombay High Court, they did not take it over. And I'm happy. I mean, the income tax department was very happy.
Now, on September 2010, Vodafone International Holding went to Supreme Court demanding justice. And while this was all going on, in March 2011, Vodafone International, meaning I, got another shoe cause notice from Income Tax Department, which said that I should be paying 100% penalty as well on top of the TDS, which they are saying that I'm liable to pay. Like, seriously, man. But the Supreme Court stayed the penalty amount and the proceedings continued.
And then came the fateful day in January 2012 when the Supreme Court passed the final decision.
And this time the decision was in my favor, that is in the favor of Vodafone. And the Supreme Court explained why it was in my favor. It said that we are here to interpret the law, as in the Supreme Court is there to interpret the law. Hence, the provision of Income Tax Act, which state that there should be a capital asset situated in India, which should have been transferred, does not come into play here, because that is nowhere written in law as of that time. The IT department cannot interpret as it wants.
Yeah, and what the Supreme Court said was that the assets were offshore, and the provision should be looked at and not looked through, meaning that even if transfer of shares of CGP Investments gives Vodafone indirect control of Hutchison SR, the transaction cannot be taxed in India, as there is no provision supporting it. There's no current provision in the income tax laws that supports this transaction. But the income tax department has the support of the Indian government. And soon, there was a retrospective amendment in section 9, subsection 1, which was applicable retrospectively from 1961, which changed the entire game in my favor.
Yeah, so this amendment which Income Tax Department talked about was in fact an explanation, specifically explanation 5 to the section 9, subsection 1, for those people who want to look it up. And much to my dismay, the explanation said that the transfer of a foreign asset, that transfer will be taxable if, such asset, such foreign asset derives or obtains its significant value from an underlying Indian asset. Now, what this translates into in the context of the case is that as CGP Holding had 67% shares in Hutchison SR Limited India, so more or less the entire value of CGP was derived from an Indian asset, and hence the transaction becomes taxable. Hence, Income Tax Department got power to tax the transaction. And I mean, on the other hand, people say that India is moving up the rank of doing business. I know. What is this? What is this? And, if that was not enough, taking power from this explanation, I get a revised demand of 14,200 crores, which, includes the tax and interest over it, but not the penalties.
And fast forwarding a bit, on 17th April 2014, the Income Tax Department gets an arbitration notice under India-Netherlands Bilateral Investment Protection and Promotion Agreement. Let's take a pause here. That's a very long name. Let's call it INBIPA, which is an agreement between India and Netherlands to protect trade and investment done by their residents in each other's territories. And why Netherlands? Because Vodafone International Holdings is actually based out of Netherlands. So that's the reason.
Now, before anything happened in the arbitration, I received a revised demand again of 22,100 crores. And this time it includes the base amount of TDS, the interest over that, and the penalties. So I'll just break this 22,100 crores a bit. This has 7,900 crores of base demand. On top of that, a penalty of equal amount and an interest of approximately 6,300 crores. Now, approximately a year later, I serve another notice for arbitration under the India-UK Bilateral Investment Treaty, or BIT in simple terms, which is something similar to the BIPA, which we discussed earlier. My contention is very simple. The retrospective amendment which the Indian government or the income tax department did was not with the spirit of the law. That is what I say.
And the case against which the arbitration was ongoing is heard by the Permanent Court of Arbitration, which is located in The Hague, Netherlands. And, everyone knows the result that came out. It was very unfortunate for me, the income tax department, that the PCA decided that the retrospective insertion is in breach of investment treaty, and hence, there should be no tax demand. Not only that, what the PCA told me is that I would be required to reimburse partial legal costs to Vodafone to the tune of around 4.3 million pounds, or approximately 40 crores. I mean, dude, Vodafone has not paid a single penny in all these years. I've been levying penalties, interest, but I've not been paid a single penny. I lose the case, and I also need to pay Vodafone. I'm pissed now. The income tax department is pissed.
And this time I am very happy. And like this, a case which has been a case study for every chartered accountant student for past 12 or 13 years has come to more or less conclusive close. Now, what the Indian government or the income tax department plans to do is something which remains to be seen. So now we'll step out of our roles and see what is happening or going to happen after this dispute is, for once settled.
I mean, I partially disagree with you here because, I don't think that this is going to end so easily, because you don't get away easily when you piss off the Indian tax department. And what's going to happen now is that the Indian government and the tax authorities, they will probably seek legal counsel from India's attorney general and other people, other lawyers, and they'll find out ways or remedies that they can take. But I think they will most probably appeal this case in the appropriate court in Singapore. But I think, either ways, this is a much needed win for Vodafone, because they already have AGR dues to worry about. And this is something that, they could not have survived. Like if the demand was raised, I think it's a win for Vodafone, but let's see what happens.
True. And plus, in addition to this, I think that India might review all of its bilateral investment agreement, bids and repars, the treaties. And this might affect the cross-border investment and the ease of doing business as well. Because, obviously, if there are significant changes in the bilateral treaties, that will have an effect. So yeah, that's that. So well, folks, that is it on topic from our side. We tried to cover it in as much simplistic approach as possible, and we tried to incorporate all the details which have happened over the years. So we hope that this closed all the loops regarding the case. And in the video, we'll give some bits of photos or the video bits which will help you understand the topic in a better way. So yeah, do watch the video, and until next time, take care and cheers.
And also, if you have any suggestions, any topic suggestions, or if you want to know any particular financial term, you can write to us. You can shoot us a mail at podcast.newscocktail@gmail.com. Or if you just, you didn't understand anything that we said here, if you were still confused, you can, very easily just shoot us a mail. We will reply to you. We will reply to each mail that we get. So take care and wash your damn hands.